Good afternoon, Facebook family. We are so glad that you could join us during your lunch break. We're here to obviously help elevate your dreams, establish your brand, and expand legacies. Today, we're focused on your intellectual property.
I am attorney Elaine Moore Jones.
And I'm attorney Lorraine Birabil, and together we are
Elaine Law.
Law. um, Alon, would you like to tell us a little bit about what we do?
Yeah, absolutely. So we are licensed attorneys in the state of Texas. We are intellectual property lawyers mostly, but we assist companies with securing their trademarks, copyrights. We also help with securing their business formation or establishing their businesses and advising on formations. That's creating your LLC or your corporation, whatever business structure is best for you. We also assist with contracts. Every business needs a good contract base to work from. So we try to make sure that our clients have all the contracts that they need. Any language that may need to be changed from their existing contracts, we also advise on that. And in advising in regards to entering into new contracts with other businesses. So we do contract review as well. And we also offer estate planning. So that's your wills and your trust. Every business is owned by individuals. All individuals pass and die at some point in our lifetimes. And so you always need a contingency plan. So we want to make sure that we provide wraparound services for you as customer to not only protect your businesses, but to protect your legacy.
Absolutely. And so who we serve creatives. That is someone who creates, right? Sometimes people ask us, is there a certain type of creativity? No, if you're a creative person, then you probably need intellectual property protection. So if you're creative, we are the lawyers for you. If you're an entrepreneur, sometimes creatives don't think that they're entrepreneurs, but they are. There is a business to the creation that you're making that you're seeking protection for. And so there is quite a bit of intersection between business law and intellectual property law. And so we do serve creatives and we serve entrepreneurs.
All right. Yeah, how can we be reached? That's the number one. We want you to be able to take away our contact information. Once we give you all this great information today, you can always visit our website. It's elainelawgroup.com. We also archive all of our videos that we've done in the past. So our estate planning, our small business video, our business 101 video, formation videos, all of those videos are on our website at www.elainelawgroup.com. You can also email us at legal@elainelawgroup.com. That's LEGAL at elainelawgroup.com. You can reach us by phone at 214-432-3113. You can also visit us on our social media handles. Follow us, follow, subscribe, all of the above on all of our social media handles. Everything is found above Lorraine and I here. But on Facebook and Twitter, we are Elaine Law Group. On Instagram, we are the Elaine Law Group. And we also have a YouTube channel. So catch us on YouTube as well. And Twitter. I'm sorry, I did Facebook and Twitter. Did that one already. So yeah. So anytime you want to book a free consultation, you can do so through our website as well. Scroll down to the bottom and contact us. You can schedule your consultation. The consultations have been very beneficial to many of our potential clients, and it gives you some idea and some one-on-one time with us, aside from our lives as well. So.
And might I add, for a lot of people, they like the consultation because they're getting that sort of personal advice on their particular situation. This is an educational Facebook Live that we do, as are all of the ones that we do. They're informational. It does not establish an attorney-client relationship. However, if you schedule a consultation, that is protected by attorney-client privilege, so that it is a safe space where we can give you legal advice based on your particular needs and situation. So, but I hope everyone's ready to get started. I know we are, so we are going to dive right in. As questions come up in your mind, feel free to put them in the chat or reach out to us on the DMs. So yeah, let's go ahead and get started.
So today we decided to take you guys into the world of copyrights. We haven't covered that yet in one of our lives, but we thought it was fitting for Black Music Month. So a lot of our Black artists are oftentimes taken advantage of because of a lack of knowledge. And so we don't want that to be your excuse. We want to be able to provide you with at least the basics, the basic knowledge. And most of this can be found at copyright.gov. It is the United States of America's Copyright Office, and it will provide you with a lot of step-by-step information, overview, and the like. And of course, we're always available to assist you as well. So that aside, what is a copyright? So a copyright is a type of intellectual property, and it mostly protects, and it does protect the original works of authorship. So that's as soon as something is created by you, you take it out of your mind, you put it on paper, and you put it in a fixed medium, it's then a copyrighted work or a work that's eligible for copyright protection, and it is a copyrighted material, but it does have to be written down or put into a tangible format. That could be in writing, that could be in print. Different types of intellectual properties that can be protected by copyright include paintings, photographs or illustrations, your blog posts, movies, architectural works, choreography, sound recordings. Most importantly, we're talking about, so when you want to bring this full circle to discuss music, so your sound recordings, your productions, your written songs, written execution of music and lyrics. So any musical compositions, even computer programming, so video games, art, the movement that that maybe the art form takes. So for instance, on your Apple, if you're an Apple subscriber like me, the swipe that could be protected as well. So that programming that created that swipe, or the programming that created the visual appearance of the image, because it's like an art, so it's a work of art. So they can be protected as well.
Now we're going to transition to who can own it, right? I'm sure that is something that may be on your mind. And so who can own a copyright? We talked a little bit about this earlier, just want to go a little bit more in depth. If you are a creator, you're a creative person, then you own it. That means literally anybody who is creative can own something that would be copyright protected under the law. Once you create an original work and you fix it into a medium, it used to be old school tangible medium, but today that does now include digitized creations. So for example, if you're a photographer, but you never print out any of the photos, that is still copyrightable material. It's just in a digital format. You could argue that it is saved on a storage somewhere in a server, what have you, a memory. And so in any case, it's in a fixed form that is protectable. Photos, books, records, obviously those tangible mediums, you are the author, then you're the owner. You can also own a copyright as a work made for hire. Many business owners come to us because they've hired a graphic artist to design their logo, for example. They have hired a videographer to shoot an opening for a second location or what have you, a grand opening. They've hired a photographer for headshots for their professional website. These could be considered work made for hires. These are companies, organizations, or other people besides the creator that own the copyrighted work. It establishes that the works were created within the scope of employment, if it's for an employer, or work made for hire if the entity or person is an independent contractor, if you commissioned the work. So for example, like I brought up the photographer, for example, that person might be an independent contractor. And you're basically in writing designating that it was a work made for hire through contract regime. Copyright ownership can also come from contracts like we've been talking about, like an assignment agreement. An assignment agreement basically assigns the rights to someone else. It could also be through a will or bequest. One of the famous examples is Marvin Gaye's work that always the people are still talking about that comes up from his heirs. And so that is an example. You may not know that you own the rights to something right now, but someone that you're related to may pass and all of a sudden you're the owner of intellectual property. So there are lots of different ways and different people or entities or companies that can actually own a copyright.
Exactly. So jumping into music and just expounding on that a little bit more, many of our musical compositions are joint works. So we want to talk about and highlight what's considered joint works of authorship. So you have on a musical piece that's been created, a record, a freestyle. Yesterday was the Houston's holiday of the June 27th, not yesterday, Monday, June 27th, freestyle, right? So you have multiple rappers on one piece of music that was created by a producer. You had vocalists, you had instrumentals, you might have had writers. So each co-author, they're gonna own what's considered like an equal share of the work. And then each co-author also owns an undivided interest in that entire work. So what does that mean? Like, can they reproduce it? Can they get royalties on it? Can they perform it? A lot of the times the answer is yes. But that's why those contracts are important, making sure that you have in place who owns what copyright. So any co-author without permission of those fellow co-authors can grant a non-exclusive right to work to other third parties. Each co-author does have a duty to account to the other co-authors any profits that are obtained or any additional exploitation of the work. But you can also assign your rights. So you can say, hey, I no longer want to perform this, or you can have this share, my share in the rights to this performance piece or this authorship piece or what. But for each artist, it's important to make sure that you establish your copyright ownership in the work, and make sure that you have either the contractual basis upon which you're filing for your copyright. It could be an assignment to one group. It can be an assignment to an individual, or you can just maintain your equal shares of ownerships in the authorship. So that can get a very convoluted and definitely will require a lot more one-on-one execution with with your lawyer. But it's important to make sure that when you're going into those joint works, that you understand that each person has a right to the exploitation of the work.
Thank you. And definitely, there are many copyrights that are team efforts, but in the music space, it is very often a team effort for sure. Let's talk a bit about fair use. This is a question that we get from artists, not just musicians, but across the creative space. But particularly, obviously, we're marking Black Music Month. Fair use is an issue that comes up. People sample. A lot of times they can get very creative about the songs that are being sampled, and frankly, that I'm sure anybody who Googles will find that sampling music has been a big point of litigation in the copyright space and intellectual property and music in particular. And sometimes artists credit the samples and sometimes they don't. And so I want to talk a bit about fair use and what that means and when can you lawfully sample and when you cannot, right? So fair use is the right to use copyrighted work under certain conditions without the permission of the copyright owner. Essentially, it's a way that you can use a copyrighted work without seeking the permission or acquiring a license in advance. It's typically permissible for education purposes, nonprofit purposes. One of the things that courts typically look at is there a commercial use, right, in this? Is this something that is for public comment or criticism? Maybe you're using it to make a statement about an issue that's going on in the world. Maybe, it's a parody, right? There are lots of music that's a parody, right? Is there, are there purchase and assignment rights involved, right? But typically when we talk about fair use, it's going to tip more on the side of fair use when it's for educational and non-commercial purposes. The closer and closer you get to commercial use, in terms of sales, profit motive, things of that nature, you're going to tend to lean away from it being fair use and more likely that you're going to need that license, you're going to need permission. So that is one way of looking at fair use. It's important because again, if you're sampling, depending on how you're using it, if you're using it for commercial purposes, you probably do want to get that license, right? And in the music space, there's various kinds of licenses, performance license, mechanical licensing. And I don't know that there's enough time to go into detail on each one of those. But depending on what kind of license it is, for example, some licenses in the music industry are considered compulsory, meaning that you have a required licensing fee that you would need to pay, but you don't necessarily have to ask for advance permission. Whereas there's other licenses, for example, that you do need to request permission, and the rate is negotiable based on what kind of contractual obligations that the parties agree to. So the industry can be pretty complicated, and so definitely if you're going down that space and need to exercise some of those, then you probably should talk to an attorney and to get a better idea of that. But I want to go ahead and transition to whether or not you need copyright registration. So I'll let Alon take it from there. But one of the very common questions people ask, well, if I own it because I made it, why do I need to register a copyright?
Right. So one thing I want to kind of step back to is that notion of the poor man's copyright. I think everyone has heard of that. And everyone, oftentimes, I remember when I was younger and I was writing poetry, like poetry was like my life, right? All I would do was write and yada, yada, yada. I had a church member tell me, all you got to do is take that poem, sign it, put it in an envelope, and mail it to yourself. And never open it and put it in a safe deposit box, put it somewhere and mail it to yourself, never open it. That's your poor man's copyright. We don't do that. Okay. That is not sound legal advice. The best way to assert your rights in a copyright is through registration. Why? Simply, it puts the public on notice. A copyright registration actually gives you the right to sue. It gives you the right to assert your rights instead of, okay, what am I going to do with this poor man's copyright? I'm going to run to the courthouse with my piece of paper that has a US stamp on it. You know, that's not actual legal, you know, tender to bring or to present a case in court. Could it be proof that you wrote it? Possibly, but it would come second to anyone holding a registration in the work. Is it mandatory? No, registration is not mandatory, but it is necessary and required to enforce any exclusive rights of copyright ownership. So to send those NDAs out, right? A lot of people send out NDAs and they have no proof of registration, right? It's a scare tactic. It's it's kind of a bluff, calling people's bluff or whatever. But if it doesn't have a force of registration behind it, yet NDA it's like having a piece of paper with no actual legal tender, and you're taking it to the bank and telling them you want to cash a check. Well, it doesn't have any force behind it. It doesn't have any actual money or paper behind it. There's nothing to it. There are no teeth to it, right? So in order to have teeth to even your NDAs or your takedown orders, we'll talk about that in a minute as well. You have to back it up with registration, proof of registration. It legitimizes you, it legitimizes your work, and it establishes your standing to present even a prima facie case for infringement, right? Like I said, it provides the public with notice. So basically anyone attempting to infringe on your rights, they can't make a claim that, oh, they didn't know that you were the original owner. No, you put people on notice, whether they go to the Copyright Office, do the research or not. At least it's on notice. It's in the public record. It's in the public register. And I'll say this, there are a lot of companies out here that say or claim that they'll register or protect your works or whatever. There's only one way to register, protect your work, and that's through the United States Copyright Office here in the United States. So, of course, if there's international implications, every country might have their own a way of going about securing copyright and intellectual property rights. But most countries have an agreement with the United States that it will uphold and respect any copyrights or trademarks that are registered here in the States. Did I miss anything? Let's see. Timely registration. You're going to make sure you register timely, right? It gives you the ability to request monetary damages, right? So for instance, I'm thinking of Carlton and Fortnite, right? He was not successful. That's not his real name. His real name is Alfonso. I think that's his name. Yeah, Alfonso. Wanted to sue the makers of Fortnite for using his dance. It was called The Carlton. I'm sitting down, so I can't really show you how to dance, but he wanted to sue the makers of Fortnite, but he had never actually registered his copyright for that choreography in a timely manner. I think he went back and attempted to register at a later date once Fortnite had already put the basically the whole dance on their gaming platform. And so he didn't have any standing, right? We all know that Carlton made up the dance, or that we first saw the dance on Fresh Prince of Bel-Air. You might have knowledge of it, but it was never actually registered. So he couldn't claim any monetary damages for that infringement. So you never want to get caught lacking. You always want to be proactive in asserting your rights. So making sure that you actually secure that copyright registration is the first step in asserting your rights. Do we want to pause for questions? Do we have any questions yet? No?
I see some reactions here, but no questions yet. And I just want to highlight your creativity in explaining that because sometimes people don't think about that. You know, they think of a dance and they don't think, I could, I made this and I can register it. The moment it is fixed in a tangible form or digitized in a way that could be considered tangible, that qualifies for registration.
I like to think of it like this. Like, I mean, you save yourself the attorney's fees, the time and effort to have to prove your case when you actually register first. So that's not only copyright registration, trademark registration, business registration, all that good stuff. So you assert your right early before there's a need for any litigation.
Absolutely. And I want to put a pin right there because a lot of times, again, people say, well, I made it first, so it's mine. I did a poor man's copyright. The law says it's mine. I've never seen anywhere before I made it. You're basically giving yourself the legal standing by doing the registration. That's uncontrovertible, essentially, that you did in fact register it in the public domain, and that basis of doing that is what makes it recognized. You may have a movie idea, film idea, all of these things. If you put them in a tangible form, you can register it. And that's the other thing about books that sometimes people don't think about. When you option it for a film, that's a revenue opportunity, but your ability to do that a lot of times is contingent upon you owning the intellectual property for it. And a lot of times investors, they want to see that asset and intellectual property copyrights, they're considered business assets. And so you don't want to deprive yourself of that opportunity. I want to briefly talk about DMCA, Digital Millennium Copyright Act. That's a lot of letters, right? Sounds like a lot, but it's actually one of the number one tools in the belt of someone who owns a copyright. Basically, it's a law that was passed when Congress was trying to modernize protection of intellectual property. And one of the things that it does is that if you find that your work is possibly being infringed upon online, think YouTube, right? If you find it on YouTube, social media, whatever, regardless of the platform, you can request a takedown. Which basically means that you can obviously have a lawyer draft it. If you decide to go to YouTube University and find a letter on Google or what have you, it may not have the elements required to meet the legal requirement that Congress drafted into the law. But basically what it does is that if it is an appropriate takedown letter, you're basically putting the provider on notice that there is a belief that your registered copyright has been violated. And because you have the registration, you have the legal standing to make that request to take it down. There's a carve out in the law that prevents providers like Facebook, like YouTube, like TikTok, I could go on down the list, Instagram, Twitter, what have you, Foursquare, Tumblr, people still use Tumblr, but wherever you're finding the potential infringing content, there's a carve out in the law that basically prevents them from being liable. But what they are required to do within a certain amount of time is to take the content down. So if you have noticed them, they're required to take the content down. It may sound like it's not a tool that's helpful because it eviscerates their responsibility if they just follow the requirements. But as a copyright holder, it's actually quite strong because it will basically require that the party who posts it demonstrate that they have the right to post that, whether it was through an ownership of that copyright material, whether they had a license to do it. It shifts the burden essentially away from you. You own it, so you already have that burden met through registration.
I think we lost Lorraine. We're gonna pause for a second, see what happened there. Mm. All right, so Lorraine's gonna try to get back in. So basically, we'll continue with the presentation until Lorraine pops back on. But do you need a copyright registration? Um, Bottom line, if you wrote it and you want to protect it, then you need it. You should definitely secure copyright registration. But that brings me to what we offer as our law firm. It definitely attempts to serve as your wraparound services. We offer copyright registrations. We will prepare your copyright application. We will submit everything to the Copyright Office on your behalf, and will serve as your attorney of record. So any communications that are required between you and the Copyright Office, we will receive and we will respond to. We also offer copyright assignment agreements. That is where you might have hired a freelancer to create your copyrighted materials or your materials for your promotion, business promotions, and things like that. And we offer a document which allows that person to assign their copyright rights over to you as the owner of the materials, and it allows you to file for the copyright. Non-disclosures. So if you have a business that creates a lot of materials that you would like to keep secret or like to keep within the business itself, you might need a non-disclosure agreement drafted or a confidentiality agreement drafted separately or inside of maybe your employee handbook or manual or the like. And we do offer that as a service. We also offer independent contractor agreements, which also would include sometimes those copyright assignment agreements as well. As mentioned before, we offer contract review, contract drafting, contracts galore. The world is made up of contracts, breaches of contracts, and all that good stuff. But we try to just get you right the first time. and assist you with any of your contract review revisions and the like. We also assist with license or create or and assist you with maybe an existing licensing agreement. That is the right to someone, giving the right to someone to utilize your intellectual property. So we can draft those for you, negotiate the terms for you, and finalize those for execution on your behalf, as well as the artist and creator. It looks like Lorraine's getting back in. Let's see. Again, back to the DMCA, the Digital Millennium Copyright Act. We do draft those takedown orders and requests when you need someone to take down any of your copyrighted materials from their social media, their websites, any platform that is being utilized without your permission. So we do assist with creating those takedown letters, as well as drafting of demand letters. So we can draft those demand letters for you, requested that any of the kitchen sink we need to throw at them, we can, demanding and asserting your rights in any intellectual property. So Lorraine, we're pretty much wrapped up here. I've gone over why you need a copyright. We've gone over the Digital Millennium Copyright Act. Was there anything else that you wanted to add to that portion of it?
Oh, no, very confident that it was covered. I just want to go into the chat here and see if there are any additional questions. Give me just a second to double check here.
Sure. So if you have questions or need any consultations, again, I'll just repeat to you our contact information. We can be reached by phone or text at 214-432-3113 or online at www.elainelawgroup.com. Lorraine? Any questions?
No, we don't have any questions. I also want to remind the audience that we're going to post, and in case you missed it, some information and comment in the video. So if you go to the comments in the videos after this, there'll be a link to where you can sign up to be added to our email list. And if you sign up on this list, you will also get a free fair use checklist. I know it's a topic that we covered a bit during our session today, our informational, the workshop. So if you have questions, you're an artist, you're like, well, I want to get a better idea of some of the factors that they look at for fair use, commercial versus commentary, for-profit versus nonprofit usage. When do I need to ask for permission? We'll provide that free checklist for you. Doesn't cost you anything to learn about that. So I think that will be, for certainly a great item of value if you're a creator making works, to have that as a baseline as you continue to create.
Yeah, so overall, we just sincerely thank you for joining us. If you're joining us live, if you are watching the video in case you missed it, we thank you for tuning in, and we want you to know that we are here for you, so you can always register and sign up to get our updates, as Lorraine mentioned. We've given you a lot of information in this 45-minute presentation. We want to make sure that you thoroughly understand the benefits of having a copyright. So again, visit us at elainelawgroup.com or on any of our social media handles here, Facebook, Twitter, Elaine Law Group, Instagram at the Elaine Law Group, and feel free to reach out to us if you need help with your business needs, estate planning, intellectual property, including trademarks and copyrights, business formations, and contract, and all that we can help you with, we will. If we need to refer you out, we certainly will as well. So.
Thank you, everybody. Hope you have a great afternoon and be looking for those links.